Good morning, everybody, and welcome to Planning for the Recovery, episode 5. This is the episode in which we're going to talk exclusively about virtual planning events. That's virtual planning inquiries, virtual planning hearings, and High Court cases done virtually in the administrative court. I'm joined, as usual, by the team. So I'm joined by Thea Osman-Smith, who's in Shropshire, James Corbett-Bircher, who's in London, Jack Smythe, who's at home on his parents' farm in Hertfordshire, and Leanne Bucky-Thompson, who is in Sussex. Now, we've all been extremely busy over the last couple of weeks, and so James and I and Leanne are all going to talk about the virtual inquiries that we've been doing. James and I have been in an inquiry for the last 2 weeks. Today is the last day we're closing submissions. And Leanne is my junior in the next 2 cases that I have coming up, and she's been helping me with the case management conferences and the technical meetings and the preparation of all the evidence. Then we're going to hear, and that's going to take about 25 minutes, then we're going to hear from Jack, who had a virtual planning hearing this week in Wychavon, and he's going to talk about 10 minutes of his experience about that. And then finally, we're going to hear from Jack and Thea, who yesterday both had a High Court case, the same High Court case. They're both on the same side, but for different parties, and they're going to be telling us about how that went as well. So we're going to begin with planning inquiries, and on the 13th of May, Robert Gendrick, the Secretary of State, made clear that virtual planning inquiries would be the default setting going forward, and we don't know how long that's going to last, but certainly for the foreseeable future, that is how planning inquiries will progress. We know that he was encouraging PIMS to progress that, and PIMS also provided their own press release. And now Leanne is going to tell us about that.
But PIMS then issued a press release on the 28th of May as well, which confirmed, of course, all of the very hard work that they've been doing behind the scenes to try to implement virtual events using digital tools in place of face-to-face. And what we therefore know from that is that cases that have been postponed due to COVID specifically are going to be being prioritised. In June specifically, there's going to be 10 planning appeal hearings, 8 inquiries as well taking place. The remaining are going to be rearranged at the earliest opportunity, so they'll presumably be gotten to as soon as they can be. Now, of course, 2 of the planning inquiries, I'm junior to yourself, Chris, and I know you're currently engaged in one with JCB at the moment. Now, given the time that understandably it will take to arrange all of those inquiries and hearings, PIMS has been liaising with parties and others that are involved in the events to organise these CMCs. And the purpose of those is, of course, to discuss how going virtual is going to work with all of the parties being able to participate. Now, I've had 2 of these with yourself, Chris, so far. The purpose of that, of course, is to allow the inspector in the case to first go through with the parties that are engaged in the inquiry all of the changes to the national guidance and the work that PIMS has been doing, just so that everybody understands what that is, and then going through the practical challenges and arrangements for such an inquiry as well. So that's an opportunity, Chris, for anyone in the parties to discuss any concerns that they might have with the process, to learn from the inspector in brief about the technology that's going to be used for the inquiry itself, and also to go through the practical arrangements, so things like how the notification letters and site notices are going to be sent out and what they're going to look like, looking to the programme and how that will work, in particular the running order, bearing in mind, of course, the virtual nature of the event, things that means that things need to run slightly differently to how they would at inquiry in terms of time slots.
Great, super. Thank you very much. And we've got a technical meeting coming up, haven't we, tomorrow, on behalf of our clients for a Secretary of State case in July. Right, now next, thank you, Leanne. Next, James, the documents. How do we deal with the documents of these virtual events?
Chris, so documents, of course, are the lifeblood of any inquiry, be that physical or virtual. And viewers may be asking, do I need to go fully electronic? And if so, how are such documents to be published online? Now, the answer is that you can use paper documents if that works for you However, inspectors are plainly increasingly using electronic documents for the core documents with a much smaller number of paper documents. Now, in all virtual inquiries to date, the Council have published the documents on a specific web page on their website. And that web page was so accessible in our inquiry last week and this week that the inspector indeed was using that web page to access certain documents. Now, there are potential further changes afoot to documentation and the rules on documentation to ensure that parties are working from a common reference system and one that's accessible for all participants and those observing the process. And I and other planning barristers have been working on the concept of a digital bundle with a continuous pagination, which is standard in the courts. And of course, if that was implemented, that would revolutionise inquiry documentation.
Yes, and I think undoubtedly it is the case that we're moving to more electronic documents. But for anybody out there, including any inspectors listening who don't really want to lose the hard copy documents because of all the highlighting and the post-it notes, well, I have to say I've used hard copy documents all the way through this inquiry, and I'll continue to do so. But there's no doubt the electronic ones certainly assist with public participation. So thank you very much, James. Leanne, the technical meeting, I've mentioned we've got one tomorrow. What happens at the technical meeting?
So, of course, because this technology is going to be new to so many people involved, and we have to remember, I think, as well, that you're going to have people involved in inquiries that may not have been involved in inquiry at all before. It's really important to have a test event, and PINS, I think, has been really good and eminently sensible in arranging these. It's an event that takes place with all of the main parties a week before the inquiry is due to open. And what that does is it allows all of the participants to test out their digital connections and the procedure that they would be going through wherever they're located in order to access that virtual inquiry. So the case officer will confirm the date with everybody and the time for the test event prior to it and send out an instruction email. That enables everybody to know what they're going to expect of the event and how they can join the test. So, Chris, as you've said, our first one's tomorrow, and we therefore had that instruction email. So we know that events normally are set to take around 30 to 45 minutes. I have to say I have heard from somebody else that theirs took around 2 hours, but I think that's because, of course, a technological issue did arise with them and that needed to then be remedied. But ordinarily 30 to 45 minutes seems like a fair amount of time. PINS advises ahead of the event that, of course, parties familiarise themselves with the functions of the technology that they're using, just to try and speed up that test and ensure that everybody's ready for it. People should, of course, switch off their cameras if they have a slow connection, and that will help that event to push through, and actually for the live event as well. People can join via telephone, just as they can for the actual event, either if they don't have the capacity to use video or if they feel uncomfortable with that. We are being advised to attend that virtual event 15 to 30 minutes beforehand. For obvious reasons, we want to make sure that everyone has a chance to access and be ready online for that event to start. And what will happen then is, once you have accessed prior to the start time, the case officer will then admit you when ready. So you'll all go into what's referred to as a silent lobby, waiting for that event to start. When we actually then have the test, it's inspector-led, and as usual, parties invited to speak as and when the inspector feels it's appropriate. So I think that's a really sensible course of action for PINS to take, Chris.
Yeah, and indeed throughout the whole process, you go into that lobby and then the inspector is brought in at the end of that stage. And this week it was Helen Skinner who was meeting us all in the lobby and saying hello and then asking us to turn our cameras off. So next, move to the technology. James, what is the technology that PINS are using for the virtual inquiries?
So, Chris, simply put, they're using MS Teams, which is a very user-friendly interface. It's got a certain formality over Zoom, and the functionality is very strong with easy one-click sign-in, screen share, and, of course, many other features.
Yeah, and to be clear, that PINS have made it very, very much the case that they will not allow people to use chat. So you're not allowed to use chat. The inspector won't use it, and the inspector won't look at it. So there are functions that they can't disable, but they don't want people to use those either. Right, now, next I'm just going to mention about the location of the team and the witnesses. Now, in our inquiry, we had two different approaches this week. I had most of my team here in chambers with me. I found that extremely useful. We were, of course, social distancing and there was hand sanitizer everywhere. However, it is really useful to be able to talk to your team as it is in a normal inquiry. In contrast, the council were doing it with everybody in different places, although a couple of the officers, not the witnesses, were in the council offices. It obviously depends on people's circumstances, whether people are at risk, and also their appetite and appreciation of the risks. But it is a matter for you. PINS are not dictating how an appellant or a local authority, or indeed how anybody participates in this event. Obviously, the inspector is remote, and the inspector, certainly at our inquiry, was operating from home. It becomes increasingly easier to work together with the social distancing reduced as of this weekend. But I have to say, I think there were very significant benefits to having the team largely in one place. Now, back to James, and tell us a little about how we've been communicating as a team during the course of the inquiry.
So with this kind of communication, it's really important to plan it in advance. I think it's also helpful to distinguish different scenarios. So you have notes to counsel during the examination of witnesses, which need to be short and focused. And outside that, notes, general notes to counsel and the rest of the team, which of course may be longer. And there's also the additional issue of ensuring that the witness who's on the stand is not contacted by electronic means of any form. So for short form messaging, we found that the best route is using WhatsApp, which is effectively like a digital post-it, and for longer form messaging, conventional email. The advantage of WhatsApp is that it's single channel, so it doesn't get mixed up with other email, and it encourages shorter, more focused messaging. However, of course, it is somewhat informal, and the odd emoji may find its way into the flow of notes sent within the team. In future, I can see teams setting up their own individual messaging system, perhaps using Slack or some other contemporaneous messaging system. Now, a key issue that I referred to before is keeping the witness off any WhatsApp messaging system whilst they're giving evidence. Now, that can either be achieved by simply asking them to put their phone in another room, but some others, including you, took a stronger line and took the whole team off the WhatsApp for the duration of that evidence.
Yeah, and I think that's really important. So the WhatsApp was really useful to talk to the team when the witnesses on our side aren't giving evidence. But there's no doubt that you want to not only ensure there isn't any inappropriate communication, but also that is very obvious to everybody, especially members of the public who are watching. So all electronic material was turned off. And in the breaks, actually, we left the cameras and the microphones on. As the barrister, I sat and was visible. Or the witness was sat and visible at all times to see that there was no communication. The witnesses didn't use the computer in the breaks, not because they would want to, but because of the impression that might give to members of the public. And I think that's a really important thing for people to watch. I don't think PINS will insist on this, but I think parties who want to demonstrate that they understand where the sensitivities lie in the use of this virtual format are able to demonstrate that and be able to show everybody just how careful they're being about the communication. Right, now in terms of the ability to involve third parties, James, your observations on what we've experienced these last 2 weeks?
Yes, Chris. So what I've seen is that third parties have so far tended to group or collect their submissions with one spokesperson, for example, a parish councillor. And so what that's meant is there's been relatively few interested parties who actually speak. However, inspectors have been very open in allowing members of the public to ask questions of witnesses, even if they don't have Rule 6 status. And that has worked fine if those questions to members of the public are short and focused. Some of the questions, just as in a physical hearing, have tended to veer more towards submission than a question. But the third parties have been very quickly steered back onto conventional process and actually asking a question of the witness. So I think that fears that the process would be slowed down or overtaken by third parties have so far proved unfounded. And overall, the involvement of third parties has been almost equivalent in scale and form as in a physical inquiry, in my experience.
Yeah, I mean, one issue is obviously PINS have chosen Teams to allow people to join by telephone. But obviously, if you're on a telephone, then there are charges for being on the telephone. So we've had people who do come in and then drop out of the meeting at fairly regular intervals. And that obviously leaves a message, and that can cause disruption to when a witness is answering a question or an advocate is asking it. If we just move on then to the issue of technical problems, you will have technical problems, that's almost certain. And there are various things that are likely to happen. I have to say, coming into Chambers alleviated all my concerns about the technology because it was no longer my problem. I could concentrate on the case, and we have IT people here to support us, as well as all the other people assisting on the admin of Chambers. But if you are doing it at home and it cuts out, it's not necessarily something to worry about. If you're the advocate or the witness, then obviously that's going to cause some concern. And inspectors have left the meeting, left the inquiry, so that they always have those representatives from both sides and the witness on the screen and being able to be listened to if they're present. But if somebody drops out, as happened with myself when I put a load of heavy files on top of the keyboard and caused my team to be cut out, then the reality is that the inspector will leave and wait till you're reconnected, and that's when you go back through the lobby system. I have to say the technology problems were there throughout, not persistent, not disruptive, but they are there. And if for anybody who says, well, this is how it's going to be done in the future, I think they'd need to reflect really carefully, because you don't have any of that at a normal inquiry. I think it's fine to involve people in this process electronically as part of the inquiry package, but to imagine that we should be doing this when it's far better to do it in a single room where everybody's present is blindingly obvious when you come across some of these technical problems. Right, now I'm going to turn to the issue of giving evidence. I have to say that the way in which the evidence was given and the way in which the cross-examination evidence in chief proceeded led me to conclude that it wasn't really any different from a normal inquiry. Leaving aside those occasional technical issues, we were using in Chambers screens that you would largely go into a pub and watch football on, which we can do on Saturday, apparently. And therefore, the image of the person that I'm cross-examining, for example, Nick Ireland from Iceni, was as if he was in the witness box in front of me, possibly even a bit larger. And so I didn't find it disruptive. But that's the position from the advocate's point of view. We've got Christian Lee, or I hope we've got Christian with us. And we want to ask Christian about his experience and to speak about how he felt it. So, Christian, are you with us?
Yes, good morning.
Good morning. Good morning. Recovered from the inquiry?
Yes, yeah. A good night's sleep.
Yeah, you still got my closing submissions to go, but we should get that done in 3 hours. Right, tell us how it was for you. What was the experience like?
I think generally, as you say, it felt quite normal, and I wasn't really expecting it to. The two main differences were the technology points. I think my technology dropped out at one point during the cross-examination, but as you say, PINS have dealt with that quite effectively, and they basically called an adjournment at that point, and then we went to lunch, so it wasn't a problem. The other point is, and it's really a point that we're all kind of becoming used to in the current new normal, really, is the screen time. It is quite intense to be on screen for a long period of time, and I think it is more intense than giving evidence in person. But PINS have quite effectively timetabled the inquiry to ensure that there are breaks quite regularly during the day, and in our inquiry they aim to adjourn the inquiry at 3:30 every day as well, which is useful. So yeah, that's my experience, really.
Yeah, and I have to say those breaks, we had an hour. We started earlier at 9:30. Started on a Monday because nobody's travelling anywhere, and we had a half an hour break and then an hour and a half session before lunch. And that half an hour break is designed specifically to give us a break from the screen. Although if you're in Birmingham city centre like I am, it gives you time to go and get a Pret coffee. And then in the afternoon, we just had one session, and I have to say that felt like a very pleasant inquiry day. And to finish then, but you are getting tired. There's no two ways about it. What about the questioning? I should emphasise that you lost your connection not by pulling out the wire when you faced a difficult question, but how was it when you were being questioned? Did it feel at all different?
No, not really. It felt very much like being in the room. It was slightly strange at times when the opposing barrister's technology dropped out and his video needed to be turned off. So I was being asked questions by someone that I couldn't see, which was a little bizarre. But no, generally speaking, it was fine, and it felt very much like a normal inquiry.
Yes, absolutely. Well, I think he was in a different location this week, leading to suggestions that barristers will be doing their cross-examination from their Tuscan villas. That is just a terrible rumour and not at all true. But good. I agree with you. I mean, I think it was remarkably similar, wasn't it, really, in many ways?
Yeah, absolutely.
Yeah. Good. Well, Christian, thank you very much for joining us. And we're back to the inquiry straight after this. But now I'm going to hand over to Jack, because that's enough about an inquiry. Many, many more cases are dealt with by way of hearing. So, Jack, tell us about your virtual hearing that took place this week.
Thank you, Chris. On Monday, I had my first virtual hearing. It was a modest appeal in respect of 10 self-built dwellings. The local authority was Wychavon District Council in Worcestershire, and I was for the appellant. It was due to take place in May, but was adjourned by virtue of the lockdown. I told my planning consultant to tell PINS that we were happy for the matter to be determined as a virtual hearing. I didn't expect anything to come of it, but then out of the blue, PINS sent an email saying there'll be a virtual hearing in our case in a fortnight. A short case management conference took place the week before. This took about half an hour. Its purpose was to familiarise ourselves with the Microsoft Teams platform, agree that the matter could be dealt with in a day, agree the running order, and also determine whether any members of the public or third parties were intending to attend. The virtual hearing began at 11:30 in the morning on Monday. The appellant's team were all sat in the planning consultant's office. We sat at 3 different tables at different corners of the room. The 2 planning officers were sat together in a room at the council building. The inspector was David Richards, who was at home, and there was a single member of the public who attended the whole event. It was a fairly crunchy appeal, which turned on matters of planning policy rather than allegations of environmental harm. The key issues in the case were twofold. Firstly, was the tilted balance engaged on account of the fact that the council didn't have its own self-build policy within its development plan? And secondly, to what extent was the council meeting the demand for self-build? There's an argument as to whether planning permissions purporting to grant self-build could count if there's no condition or unilateral undertaking to enforce them. The hearing comprised 3 sessions, 11:30 till 1, 2 till 3:30, and then 3:50 to 20 past 4. A PIN's IT officer was there at the start to greet us and make sure that everyone was settled. He then disappeared when the hearing got underway. If you were not speaking, you were muted. If you were not involved in that particular topic, you were asked to turn your video off. If you wanted to come back on a point, you use the hands up function. The 4 of us in the appellant's team all use earphones to reduce distracting feedback. And we communicated simply by talking amongst ourselves when we were all muted, or by passing notes. So in many ways, intra-team communication was actually easier remotely than is a case in conventional in-person hearings. It's certainly less conspicuous. The whole event proceeded smoothly, albeit that proceedings were interrupted at one point by the inspector's cat making an unexpected appearance. The screen share function was not used at all. No additional documents were relied upon by the parties during the course of the day. Given the nature of the controversy, the hearing was a focused affair, with primary consideration being given to particular policies of the development plan, appeal decisions, and the parties' respective appeal statements. Notwithstanding the fact that officers were sat in the heart of the council building, they experienced some intermittent Wi-Fi issues. The inspector was keen to keep the show on the road. Given that this was the inspector's very first virtual event, I was pleasantly surprised that he took such a pragmatic approach to those issues. So, for example, if the screen of a particular participant froze, he carried on, provided the audio was unaffected. The night before the hearing, the council provided comments on the draft unilateral undertaking. The lateness of the document caused us some problems. Again, the inspector dealt with the matter pragmatically. He took up my suggestion to kick the matter off, so that the appellant was given the opportunity to provide a revised unilateral undertaking within 7 days, then the council to give comments 7 days after. We made a cost application. This didn't take up any time at the hearing, as at the CMC, the inspector had indicated that he wanted the matter to be dealt with in writing. So that's what we did. So what did I make of my first virtual hearing? 4 points occur. Firstly, I regard it as a very positive experience. It worked well, and I understand that all parties had confidence in the process. Secondly, in most important respects, it operated as a normal hearing, albeit that the court participants were in 3 separate bubbles. Thirdly, I think upon reflection, we didn't make full use of the technology available, such as the screen share function. But I think this is more a consequence of the particular subject matter of our appeal, which didn't lend itself so much to that, than sort of inherent scepticism on our part. I think the final observation I have is that the hearing itself took about as long as I would have expected it to have done had it taken place in person. So whilst occasional Wi-Fi interruptions slowed us down a little, correspondingly, speaking to a screen encourages concision and is a verbosity repellent. So overall, in my view, it was time neutral. Over to you, Chris.
Yeah, very good, Jack. Yeah, actually, that development you were promoting is just around the corner from my mum, and she would have, I'm sure, gladly participated. She's 80 years old, but she's perfectly able to use a computer. She's constantly all over my Facebook page, so she demonstrates that to me every time I say something. Good. And just to be clear, the arrangement you had then was your team were together. Is that right?
Yes.
Yeah. Okay. Now, Erin, I don't know if you can hear me. We're getting technical support this morning from Erin, but we've got a couple of pictures of the virtual inquiry that James and I did this week. And if they don't come up, you can find them. Here we go. This should work. There. Now, lots of comments about this, suggesting that it looks like something from Star Trek, that I'm playing Captain Kirk. People wondering why everybody's a bit further away from me than normal, but that's just because of my boxes all round. But that's how we did it. James there you can see in the foreground, and then other experts sat at their tables. And we found that worked perfectly well. One of the things we were able to do when the other side were talking was mute, so as not to cause any noise, and then we could just talk normally. So I agree with you, Jack. The ability to communicate is actually enhanced this way round, although obviously if you were laughing at a particular answer, then you have to do what Premiership footballers do and make sure they can't see what you're saying, or there's any lip readers. So just be a little bit careful about the extent to which you're reacting on screen. And also how the screen itself looks. Erin, I don't know if we've got the other picture there of how the screen was split up. There's the inspector, Mike Hayden, on the left-hand side. My opponent, Simon Pickles, in his attic at the top. And then there's my witness, Andy Moja from Tetlow King, in another room. Deliberately in another room, and the camera in that room in Chambers is down on the witness, so we could all have a good view of him and to check that nobody was around him. So, Erin, thank you very much indeed for that. Now we're going to move to virtual court hearings, and Jack, you've had a busy week. Not only have you been doing your hearing, but you've been in the High Court and on the same side, I think, as Thea. Is that right, Thea?
Yep, that is right, Chris. Same side, different parties. So this was my second virtual High Court hearing. The first was a Section 289 challenge to an enforcement notice in May. Now, this case that Jack and I were involved in at the start of the week was due to be heard in April, but the claimant's barrister had symptoms of COVID at that stage, unfortunately, so it was pushed back until Tuesday. So this was a full-day judicial review in front of Mr Justice Robin Knowles, and it was brought by a parish council who were challenging the grant of planning permission by the council to my client for housing development on an allocated site, allocated for housing development, I might say. Jack was there for the council, I was there for the interested party, and the claim didn't actually raise any novel points of law. There were only two grounds, and the second ground was really related to the first. So it wasn't a very complicated or difficult case, which probably made it ideal for this format of hearing. There were two bundles, the hearing bundle and the authorities bundle, and my client actually helped to prepare those because the parish council didn't have a solicitor, and it was easier for us to prepare them in line with the advice given by Mr Justice Holgate in April. So they were, the way in which they're paginated, they were hyperlinked, so that you could access the documents really easily in that way.
Yes, so we started at 11, and unusually for a High Court hearing, we had two breaks as well as an hour-long lunch. Only the judge and the barristers had their cameras and microphones on, and everyone else was muted. We all gave our submissions. Then the judge took a 50-minute break and then gave judgment by 4:20. Of course, Thea and I won, and the issue of costs, the issue of costs was unproblematic because it's an Aarhus claim, so the council's costs were fixed at £10,000. I think Thea's now going to talk about the good, the bad, and the ugly.
Yeah, thanks for that, Jack. So in terms of the good, I found both virtual hearings have been quite quick. I mean, Jack said time neutral. I think these were actually probably both that I've been involved in have been quicker than I would anticipate. I mean, I have to say, it might be because both of the judges in both High Court hearings I've been involved in are not planning specialists. So there hasn't been a great deal of intervention. We've kind of just gotten on with our submissions and that's been fine. It might be because people don't really like looking and speaking into a screen for very long. There is something a little bit uncomfortable about watching yourself as you're giving submissions. And in Skype for Business, you're all sort of on screen at the same time. It might be because the electronic bundles are so easy to navigate. And of course, they're streamlined in line with Holgate's guidance on how these bundles should be working. So everyone can navigate really quickly and everyone knows exactly where they're going. The straightforward point, I think, is that the format works, the technology works, and I genuinely think that there is a place for virtual hearings in the future for applications and perhaps submissions on costs, so that everyone doesn't have to traipse along to court, which inevitably takes a great deal of time for both solicitors and barristers who are attending. I can't go, of course, without mentioning the benefits of having multiple screens. For me, I had the hearing bundle on one side, I had the authorities bundle on the other side, and the judge and all the parties in the middle. So that made it really straightforward for me to be able to look at all the documents that I needed to look at the same time. Jax, what's your view on what was really good about the hearing?
Yeah, I agree with everything you've said. It seems to me that the big advantage of a virtual hearing is that you're given a fixed time slot when the hearing begins. So for a final hearing, this wouldn't make much difference, as your hearing will probably be the only matter in the judge's list in any event. But if you have a shorter hearing, such as a permission hearing, they tend to be blocklisted, and you have to wait at court until your case is called on. So you may get there for 10 o'clock and not actually be heard until the afternoon. So for us lawyers, the virtual hearing has the advantage of being given an allocated time. For the court service, this is probably viewed as a significant disadvantage, because giving each case a set time is inherently inefficient. So if a case settles or finishes more quickly than expected, the judge cannot immediately start on the next case. Also, the judge is denied flexibility, for example, starting one case and then standing the matter down to allow the parties to bottom out another issue whilst they deal with another case and then call that case back on. And the advantage of blocklisting also is that lawyers waiting for their case to be called have every incentive to use the time productively to try to narrow the issues in a way which is not possible in a virtual hearing.
Yeah. Okay, so moving then on to the bad, there's a few points. Sitting in my study wearing a suit felt horribly unnatural. Taking instructions from my client was undoubtedly compromised. This was a really relatively straightforward case, so it wasn't as bad as it might be. We had a WhatsApp group open, and although I didn't say to the judge, can I just check my WhatsApp, my lord, at the end of my submissions, I did have a cheeky look to see if anyone had anything that I needed to add that I'd missed. So not so bad in this case, but I think that could potentially be compromised. And of course, you miss that interaction of being in the same place as your clients. Perhaps the worst was no lunch over the road from the RCJ at the lovely Italian. There, I had to just go to my own kitchen, which was naff. But Jack, what did you think was bad?
Yeah, well, I think our case, as you said, Thea, was relatively straightforward, and the hearing proceeded without a glitch. So the virtual hearing worked very well for us. But it seems to me that it is somewhat of a fair weather friend. So if something unexpected happens, such as an error in pagination of the bundles, or, for example, the late realisation that a particular document has been superseded, these are just the sort of bumps in the road which we're all used to dealing with on the hoof at court. But it's much more difficult to do that when everyone is sat in separate rooms.
Yeah, I mean, the judge actually didn't have my skeleton argument at the start of the hearing. For some reason, it hadn't made its way to him. Now, of course, if you're in court, you'd hand it up there and then, and the judge might go away for 5 or 10 minutes to read it. But in fact, we had to, of course, send it by email and then find an appropriate point during the day. Now, I mean, it worked because I was third on, but had I been first on, then that would have been quite tricky, and I think that would have caused some delay. But the ugly. Now, this might be a little bit unfair, but I wonder if there should be some judicial guidance on where to position your webcam, because there are ugly places that you can position a webcam, and one of them is underneath the computer screen looking right up at your face. So a little tip there for anyone involved in any kind of virtual hearing: straight on or above or even to the side is better than having a camera from down there, because that can be quite ugly.
I had a friend who was observing a hearing last week in a class action about insurance companies not paying out on their business interruption policies, which may be somewhat of a cottage industry in the years to come for lawyers. But one of the QCs who was not involved in a particular section of the hearing appeared to be engrossed with his documents. But because of the angle of his laptop, it revealed to everyone that he was in fact reading a novel. So the moral of the story is be self-aware, both literally and figuratively.
Yeah, absolutely. And be very careful about what's behind you or what can be seen, because it's all recorded as well. And if you are going to look at your phone, be very careful with that as well. Great, fantastic. Well, it sounds like it went very well, and you've won already, which is nice, isn't it? We don't get that in planning appeals. They don't announce the winner and then you get the judgment later. So well done. Congratulations on the success. That was for Roscon, I think. Is that right? The Planning Permission. And who were you for, Jack?
Melton Borough Council.
Borough Council. Well done indeed. Okay, well, I think the key lessons from all of this and from all of that you've heard this morning is that there really is nothing to fear. This is all incredibly straightforward and is also surprisingly similar. I have to say that's how my experience of the last 2 weeks has been. It is just remarkably similar to what you would expect. We've all got used to Zoom. I think as far as the inquiries and hearings are concerned, PINS have done a fantastic job. They were, as we know, subject to quite a bit of criticism about the time taken, and everybody was drawing parallels with the courts. But I happened to see something on LinkedIn yesterday where I'd written an article about the virtual inquiry, and somebody commented, it's a shame other tribunals haven't got as advanced as this. So now PINS are being seen as pioneers. And there's no doubt what they have to deal with, and the public participation is very different from the involvement of just lawyers making an application in court. A much greater parallel is jury trials, and they are still highly problematic, with the government now looking to abandon jury trials and have a judge and two magistrates, which is causing some considerable concerns to those who care about the criminal justice system and how it operates. So PINS have come up with a very practical solution. The courts have continued to deal with administrative court hearings, but that's relatively simple, I would suggest. If you have any questions, do ask us. I'm running a series of articles on LinkedIn about the virtual inquiry. I'm going to do one after this inquiry is finished about the practical procedures. Any final comments from the team at all on this? Leanne, any final comments?
Not really. That I probably would want that PINS being very much appreciated. Obviously, we want to get things moving. We want to ensure that everyone has fair access, and I think the way that it's being dealt with now does ensure that.
Yeah, good. I'm very much looking forward to having you as my junior in the next two cases in July, and just leaning across and demanding documents like I always do. You can't. That's why I want you there. Thea, final observations?
Yeah, I mean, we've had a lot of questions. I don't know, on the Q&A about the handing in of documents at an inquiry and whether doing it electronically has sort of reduced the incidence of that happening.
Yeah, well, I think PINS were very clear with the inquiries that they didn't want lots of inquiry documents being handed in because of the risk that people wouldn't see them. But I have to say we have still managed to achieve 25 inquiry documents because things arise, things are said, you have to deal with them. But so long as they go into the inquiry documentation and are loaded up, then I don't see any difficulty with why you shouldn't introduce documents, despite the best efforts to try and get everything covered beforehand. For example, in our case, there was a judicial review or there is a judicial review to the way in which the council are using a memorandum of understanding to divide up the housing distribution figures. Those papers only came to us during the course of the proceedings, so we wanted to introduce them, obviously, and we did do so, and there was cross-examination. It didn't cause any difficulty, and if you need a document, for goodness sake, put it in. Don't worry about not putting it in. We've got plenty of other documents, so it's not as if we've not been trying to get everything covered, but things just arise over the course of a 2-week case. Jack, any final comments?
No, thanks.
No? Well, Neil Pearce has commented that he felt the hearing went really well. He was your consultant in the case, wasn't he?
Yeah, he was. Yeah, he did a great job.
Yeah, I don't know, Theo, I haven't been watching the Q&A, I'm afraid, this morning, but a few people commenting on the technology and breakdowns in the sound. But anything else that you want to respond to?
No, I think I picked up on the sort of the giving of documents at the inquiry and how that was going to be dealt with. That seems to be popping up a lot. There's a few more, but I think given the time, perhaps we might answer those on LinkedIn.
Yeah, absolutely. So thank you very much, everybody, for joining us. We'll be back again with episode 6 in due course. We'll look at the policy exchange documents. And of course, everything is moving so fast in planning. This is the right sector to be in, and it's build, build, build. So until next time, thank you very much indeed. Bye-bye.
Bye.